I want to draw the attention of the Honorable Speaker.
Sir.
Speaker, sir.
Speaker, sir.
Speaker, sir, एक second. My statutory resolution is there. My amendment to the motion moved by the Honorable Minister regarding the consideration is there. And the bill discussion is there. So my humble submission before the Honorable Speaker is I may be permitted some time. Since I am the mover of the resolution. Speaker, sir, I rise to oppose both the ordinance as well as the bill which has already been introduced or taken for consideration by the Honorable Minister. The Honorable Minister in his opening remarks has made an eloquent, elaborate speech regarding the necessity of promulgating the ordinance as well as taking the bill for consideration. And I would like to dispute the arguments advanced by my very learned law minister of this country, Sri Ravi Shankar Prasad ji, that he has said in the House that it is the necessity only because of the Supreme Court judgment. Speaker, sir, the Supreme Court judgment is a 5-member judgment and it is a 3:2 judgment. You may please see that the judgment Justice Nariman and Justice Yu held that 1937 Muslim Personal Law, that is Shariat Application Act, insofar as it refers to triple talaq, violated Article 14 of Indian Constitution, the right to equality. Justice Kurian Joseph instead argued that triple talaq was not a valid practice in Islam and was therefore illegal. Sir, 2:1:2. And the minority view held by Chief Justice Jagadish Singh Kelly and Justice Abdul Nazir was of the opinion that triple talaq was undesired. The court could not strike it down and only the Parliament could regulate on the matter. So the judgment of the Honorable Supreme Court is 2:1:2 in actual figures, in actual terms. Mr. Chairman, sir, that means now the government is coming with a legislation on the basis of a minority judgment or a dissent judgment. The Honorable Minister was arguing his case that this is because of the necessities, because of the directive from the Supreme Court, we are legislating on the directions of the Supreme Court. Then I would like to ask a simple question to the Honorable Minister regarding the Sabarimala issue also is there. What is the legal position, what is the political position of BJP-led NDA government in respect of Sabarimala? What the Honorable Prime Minister has stated during the time of election in Kerala, in Chennai, in South Indian states? So I would like to seek the clarification from the Honorable Minister that it is the Supreme Court has never directed the government to make a legislation so as to ban the triple talaq. But All India Muslim Personal Law Board has given an affidavit before the Supreme Court. In the affidavit, the All India Muslim Personal Law Board has stated in the affidavit, sworn in the affidavit, that it is not the court but the Parliament to make law on this issue, and based on that minority judgment or the dissent judgment has come, only 2 judges have suggested to have a legislation. So if the government is so pertinent and so significant in promulgating an ordinance and to make a legislation so as to protect the Muslim women in the country, sir, mob lynching is there in the country. Last week also 3 persons were killed by the mob, and the Supreme Court has already specifically directed the government to have a legislation. Why the government is not ready to initiate a legislation in the case of mob lynching? So this is, sir, I'm not going to the history of this case. This is with a clear political motive to target a particular community in the country. There is no doubt about it. 3 ordinances were promulgated. Sir, 3 ordinances were promulgated. That first ordinance is on 19 September 2018, and the second ordinance is on 12th January 2019, and 21st February 2019. 3 consecutive ordinances have been promulgated so as to make the triple talaq, so as to ban the triple talaq. I can't understand what is the necessity and expedience, or what is the emergent compelling circumstances so as to promulgate an ordinance. There is no justifiable answer. Sir, continuous promulgation of ordinance one after another is lacking bona fides and with a political motive to target the community, particular community. This is a specified targeted agenda of BJP-led government in the country. That is the first point which I would like to make. Sir, you are very well aware that Article 23, the well-established constitutional position, is that it can be invoked only on extraordinary compelling circumstances. No extraordinary compelling circumstances are prevailing in the country so as to make this ordinance. Sir, the 7-member bench of the Supreme Court in 2nd January 2017 in Krishna Kumar versus State of Bihar, what the Supreme Court judgment has said, re-promulgation of an ordinance is impermissible and terms it as a fraud on the Constitution. So it is a big dictum on the part of the Supreme Court judgment against the government. It is a fraud on the Constitution. Consecutive promulgation of ordinance is not good. It is a fraud on the Constitution. Further, the court says that, I quote, the ordinance making power does not constitute the president or the governor into a parallel source of law-making authority or an independent legislative authority, unquote. So here in this case, this is an abuse or a misuse of constitutional provision, Article 123. Hence, I oppose the ordinance route of legislation. Sir, I am coming to the bill. Sir, I am coming to the bill. Sir, I have the time. As per the rules, I have the... Please, I will. Sir, coming to the contents of the bill. The contents of the ordinance and the bill are against the interests of the Muslim men and women. Why I will? Sir, as per the statement of objects and reason, the bill is intended to prevent the discrimination of Muslim women and for the empowerment of the Muslim women. The Supreme Court judgment in Shayara Banu versus Union of India, which was held on 22nd of August 2017, Talaq Bidat, that is an instantaneous and irrevocable divorce by a Muslim husband on his wife is null and void. This is the Supreme Court judgment on 22nd August 27. That means an instantaneous and irrevocable divorce made by a Muslim husband on his wife is null and void, means it is void ab initio. That means the marriage has no legal sanction, no legal sanctity. The marriage status is still subsisting. That is the position. Then I would like to know, then what is the need for a new law on triple talaq, as the Supreme Court verdict is the law of the land? And one of the fundamental maxims of criminal jurisprudence I would like to quote, nullum crimen sine injuria, unquote. That means no person shall be punished for an act that does not prove to be significantly harmful to anyone. Here, sir, after 22nd August 2017, that is after the pronouncement of the judgment, an act of triple talaq bidat does not in any way harms or violate the rights of a Muslim woman wife unless the husband refuses to perform the conjugal responsibilities, duties upon him, or the wife is forced to leave from the residential place of the husband. Only these two cases you can invoke. If that two circumstances comes, definitely we are having the 498A of the Indian Penal Code, is 498 of the Indian Penal Code, and the provisions of the Protection of Women from Domestic Violence Act of 2005 is also there. You can very well invoke it. What is the necessity and need of... Sir, please, sir. I'm over the resolution. Yeah, please. Yeah, please. Sir, Section 498A as well as the protection of provisions of the Prevention of Women from Domestic Violence Act 2005, these two are applicable. So, what is the necessity of having such a legislation, number one? Sir, number two, criminalizing a civil wrong. Sir, this is in the opening, at the time of introduction of the bill, I have very, very detailed narration has already been done. It is absolutely a personal law. How you can make a personal law, a wrong arising out of the personal law can be made a criminal law or a crime? Sir, dispute arising out of the marriage had never been considered as a crime within the purview of the criminal law. Marriage disputes in all religion are governed by the personal laws and are treated as civil in nature. Marriage, divorce, succession laws are considered as civil laws. Sir, imposing imprisonment for 3 years for divorce is not applicable to any other community. Why you are not imposing imprisonment for divorce in the Hindu community? Why you are not imposing an imprisonment for a divorce in the Christian community? Why alone in this Muslim community alone? That is why I am saying that this is a discrimination against the Muslim community. That's why it is violation of Article 14, violation of Article 15, and violation of Article 25 of the Constitution. Sir, the last point I am coming. Sir, I have the right to move the... Sir, please, I abide by the ruling. Please, I may be permitted because my amendment to the motion is also there. Sir, the third point, that is the provisions of the bill. Sir, the provisions of the bill are totally contradictory. I will conclude within 3-5 minutes, sir. I will definitely, I will definitely abide by the rulings of the chair, sir. Sir, the point is, clause 3. Sir, clause 3 says, what clause 3 says? The clause 3 says that if a triple talaq is made or pronounced by the Muslim husband upon his wife, it will be null and void. Clause 4 says that then it is imprisonment for a period of 3 years, that is a punishment. What is clause 5 says? Clause 5 says the wife is entitled to claim maintenance from the husband. Sir, my simple question through you, sir, how a jailed husband is able to provide maintenance to his wife? Is it protecting the rights of the wife? A wife who is claiming compensation or a maintenance or a subsistence allowance from her husband who is in the jail, how is he is able to give it? Sir, I will conclude. Sir, and also the Guardian Ward Act also. And the wife is entitled to the custody of the children. And also, if talaq is void and illegal, why you are separating the husband and wife from cohabitation under single umbrella? Why you are separating them? Sir, why the children is separated from the husband? Sir, my point is clause 3, clause 5, clause 7, clause 7, 3. Sir, normally what is the provision? As per the CRPC, police is the complainant and prosecution is initiated by the police. Here the woman upon whom talaq is pronounced shall be heard for granting bail. They are also not to get bail. That provision is also there. I will conclude with the one paragraph. The bill is not intended to protect the right of Muslim women, but to harass the Muslim husband. 3-year imprisonment of the husband while the marital relationship is subsisting. Sir, such a legislation, such a legislation is never even heard of. It is lacking bona fides. It is with an ulterior political motive to target the Muslim community and violate the basic principles of criminal jurisprudence.